Good morning. This is your Kelso Report for Friday, February 17th. I'm your host, Clark Kelso. Today we have cases dealing with copyright law, unfair competition, arbitration, workers' compensation, and rent control. We begin with intellectual property and copyright out of the Ninth Circuit. In order to license and enforce their copyrights cost-effectively, owners of copyrights in music and songs frequently become members of ASCAP, the American Society of Composers, Authors, and Publishers. ASCAP is a nonprofit performing rights society that licenses the music of its members and then collects royalties whenever that music is performed publicly. ASCAP also has an enforcement program to make sure that its music is not being performed without permission. 5 restaurants with attached bars opened in 2001 in various locations in Southern California and advertised live music. So ASCAP approached the restaurant owners several times between 2001 and 2007 to offer an ASCAP license, which the owners repeatedly refused. In 2008, ASCAP sent an investigator to one of the bars, and he filed a detailed investigative report with ASCAP identifying songs that had been played at the bar. On the night he attended, he heard 4 immediately recognizable songs, and the band which performed them even announced the song titles. He identified 4 other songs that were played on a CD player by writing down the titles from the CD jewel case. The copyrights in all 8 songs were owned by the plaintiffs, who were ASCAP members. They sued for copyright infringement. Instead of simply conceding the obvious, the defendants chose to litigate. Having been caught totally red-handed, defense counsel raised a series of, I thought, nearly frivolous objections to the plaintiff's motion for summary judgment. For example, even though 4 of the songs were jazz and pop favorites, were immediately recognizable, and were identified by the band itself, the defense argued the evidence of infringement was insufficient because the investigator was not an expert and there was no evidence of substantial similarity. Well, in Range Road Music versus East Coast Foods, the Ninth Circuit rejected these silly objections, holding that the identification of the songs did not require the skills of an expert and that substantial similarity is not an issue in a case where the copyrighted songs are simply performed as written. The defendants also tried to hide behind various corporate forms, but the Ninth Circuit was having none of that type of obfuscation. It affirmed the judgment of $36,000 in statutory damages and $162,000 for attorney's fees and costs. And maybe the restaurant owners now will go ahead and enter an ASCAP license. Our next case is an unfair competition claim. The plaintiff had purchased a laptop computer from HP in the early decade of the 2000, about 2003 or 4. 2 years after the purchase and just a few months after the warranty expired, he noticed that the laptop battery started to lose its capacity to hold a charge. Frankly, this was a problem on quite a few computers in the early part of the first decade. Upon further investigation, he discovered that many other consumers had similar complaints about alleged defects in the power supply for the laptop. Although there was a class action that had already been brought and settled regarding this alleged defect, the plaintiff was not covered by that class action. So the plaintiff brought his own putative class action seeking damages for HP's alleged failure to disclose that its product was defective. The plaintiff's complaint alleged claims for unfair competition. In Wilson v. Hewlett-Packard, the Ninth Circuit affirmed the district court's decision to dismiss this complaint for failure to state a claim upon which relief could be granted. Under California law, a manufacturer's duty to disclose to consumers is generally limited to its warranty obligations, absent either an affirmative misrepresentation or a safety issue. This limitation is necessary to avoid having a limited warranty obligation transformed, as a matter of law, into a perpetual guarantee. The plaintiff had alleged neither an affirmative misrepresentation nor a safety issue, so the complaint was properly dismissed with prejudice. Next, we have two arbitration decisions from the California Court of Appeal. In the first, a dispute between the plaintiff and 6 defendants went to arbitration pursuant to a contract between the plaintiff and the primary defendant. Several of the co-defendants refused to pay the arbitrator's fee, and so after a while the arbitrator terminated the arbitration. The defendant then filed a petition to confirm the arbitration award, but the trial court rejected that petition because the order terminating the arbitration was not an award, and therefore could not be subject to a confirmation order. In Snell versus Christopher, the 2nd District agreed that there was no arbitration award that could be subject to confirmation. An order terminating the arbitration for failure to pay fees is not an award. It's simply an order terminating the process. And after a termination, the case then comes back to the trial court so the matter can proceed to trial. 2nd District remanded the case for the trial court to set a new trial date. In our second arbitration case, dealt with arbitration in an employment context. Now, as I think you may know, arbitration clauses in employment contracts often have problems with unconscionability. And that was true in the case of Ajamian versus Canto CO2E, where the 1st District affirmed the Superior Court's denial of a motion to compel arbitration. Although the procedural unconscionability of the clause before the court was not as bad as many employment-related arbitration clauses, in this case the employee had quite a bit of time to take a look at it, and even had a lawyer take a look at it, the substantive unconscionability of the clause was sufficient to strike it down. In particular, the clause had the effect of purporting to waive what were certain unwaivable California statutory rights under the labor laws, and it also had an utterly one-sided attorney fee provision, which entitled only the employer to recover attorney's fee. The court refused to enforce the clause. Next we have a workers' compensation case. The defendant employer in Allied and Interstate versus Sessions Payroll Management failed to pay the premium on its workers' compensation insurance, and the trial court therefore found the employer had breached his workers' comp insurance contract. The defendant placed his workers' comp with the State Compensation Insurance Fund, which has a process for adjusting premiums based upon an analysis of the employer's claims experience in prior years. After conducting the complex analysis that's involved, the Workers' Comp Insurance Rating Bureau concluded that an experience modifier of 121% be applied to the policy premium. Instead of requesting a further administrative review of that determination, the defendant refused to pay and raised a number of meritless objections to its obligation to pay the premium. The 2nd District affirmed the trial court's conclusion that the defendant had breached its contract, noting particularly that the trial court is not in any position at all to conduct the analysis required to determine what the experience adjustment should be to the premium, and that the defendant's failure to pursue further review by the Rating Bureau doomed its effort to challenge the 121% figure in court. And finally, we have a rent control case from Santa Monica. A landlord at a rent-controlled property decided to reduce available hours of luxury spa services on the property. In particular, it lowered the temperature of a hot tub during workday hours, heating it only during evening hours, and altered a sauna's timer knob so that the sauna heated for 1/2 hour at a turn instead of the previous 1 hour. Well, as a result of these minor changes, the Rent Control Board ordered a reduction in rent by $25 per month. In Santa Monica Properties versus Santa Monica Rent Control Board, the Second District held that the applicable rent control statutes do not permit a reduction in rent based upon such a minor reduction in luxury services, absent a showing that the rent was excessive or resulted in an unjust return on the landlord's property, and that neither showing appeared in the administrative record. The appellate court ordered the trial court to grant the landlord's petition for a writ of administrative mandamus. And that's it for today's Kelso Report. Have a great day in the law.